thank you so much for being with us today. I'm Katie Sorrentino, the Director of Wellness Initiatives at Friends Life Care. And before we get going with our speaker today, I want to let you know a few things. You can find closed captioning at the bottom of your Zoom. You might have to click more, and then there should be something that says captions. So feel free to put that on if that's helpful to you. You'll also see a Q&A box if you hover at the bottom of your screen, and that's where you're going to be able to ask some questions. Rob does have to end right at the hour today, so let's get those questions in and we will get through as many of them as possible at the end of the presentation. So now I'm going to introduce our speaker. We are grateful to be joined by a friend of our organization, Rob Slutsky. Rob was named the top elder law attorney on the Main Line and in the Western Suburbs by Mainline Today magazine, and he has regularly been featured on the PA Super Lawyers list, including this year. Rob specializes in Medicaid planning, asset protection, probate and estate administration, guardianships, estate planning, power of attorney, and if that wasn't enough, so much more I'm sure that he'll tell us about. He understands how overwhelming the estate process can be and is known for his empathetic approach in helping clients navigate it. Rob has dedicated a good deal of his time to advocating and educating us at Friends Life Care as well. He provided training to our care coordinators on guardianship this year, and he just appeared on our podcast, the Honestly Aging podcast, to discuss advanced planning for solo agers. So if you haven't checked that out, I highly recommend it. But today we are thrilled to work with him again on the topic, getting your affairs in order. And I'll pass it over to you, Rob.
Good morning. Thank you. A question before we start. Normally when I do a Zoom, I see all the attendees. Are we able to do that or not?
This is a webinar format, so we won't see them, but we can see that they're all here.
Okay, great. Because sometimes I like to interact, but if we can't do the interacting thing, it'll be you and I then. We'll interact. So thank you for the lovely introduction. My practice is elder law, and I've been doing it for 30 years. And I think one thing that kind of makes me unique in the way I perceive and practice is that I have been the legal counsel for the Montgomery County Office of Senior Services for 24 years. So they have helped educate me on a more human-based practice. It's not just about asset protection. It's not just about Medicaid and things like that. I have learned a lot in practicing and working with older adult protective services. So I'm going to answer the questions that I normally ask and get some interaction. But the first question on what we call the elder law quiz, and I guess you were going to maybe share the screen or put that up or something?
Sure, let me pull that up for you right now and everyone can see that. And just tell me when to scroll around and I'll move through.
Well, we're just going to go question by question. So the first question is, what is a power of attorney? And this is, it's a simple question, but people don't always understand what exactly a power of attorney is. First of all, in general, power of attorney is in writing. So this is a document that you execute that allows you to appoint someone else to make decisions for you, whether those decisions are medical or financial decisions. One of the things that there's often a concern about is when can the person use the power of attorney? And before we go there, I should probably at least mention, the parties in the power of attorney. So the person who is giving away the power of attorney is called the principal, and the person who they're giving the power to is called the agent. So if I'm naming you as my power of attorney, I'm the principal and you're my agent. So one of the things that is often a very confusing part of the power of attorney discussion is when can the agent actually start acting for the principal? Because a lot of people have a misimpression about the document. And as the first two things they taught me in law school is two words, and it depends. So the first thing you have to do is look at the actual document, because powers of attorney can be drafted very differently from lawyer to lawyer, or if people got them online, whatever. But, it's going to be different from lawyer to lawyer. There is what tended to be an older type of provision called a springing provision or a springing power of attorney that had a condition in it that says, look, you can't start making decisions for me until I am incapacitated. And that incapacitated language in the document could be very ambiguous. Sometimes they say incapacitated. Well, I don't know what that means to the person who might be looking at this document and trying to determine whether they should accept it from the agent. So it could say incapacitated under Pennsylvania law. It could say incapacitated as determined by 2 doctors who have examined me. Could be incapacitated as determined by the individual who I named as my agent. But that always comes or brings up the question as to if that was actually requested by the client. And in most cases, it's not. Most clients don't ask their attorney to put a condition in. And typically it comes from attorneys who don't do this type of work on a regular basis. Because when you think about what we want a power of attorney to do, it's to be there as a backup in case we are no longer capable of managing our affairs appropriately. So the question that I would say is, if you happen to have a springing power of attorney, A, did you actually ask for that provision, or was it just inserted there by an attorney who really didn't explain it to you? And B, why would you want it in there in the first place? Because some people might come in one of these discussions, and this is the answer I would frequently get, is, well, they want to maintain control, or they don't have 100% trust in the person they're naming as agent. And then I stop and I say, well, wait a minute. If you don't have 100% confidence in the person you are naming as agent, and you don't want them to start acting until you're unable to advocate for yourself, aren't you kind of setting up failure there? Because if you don't feel good that the person you're naming as your agent is 100% trustworthy and will respect your wishes, even if they disagree with them, maybe you need to choose a different agent. So there shouldn't be a need, is what I'm saying, to have a springing power of attorney. You should put someone in there who you have 100% confidence in their integrity and in their intelligence and their ability to do what you need them to do, which is probably going to be communicate with your physicians, authorize appropriate and safe medical care and testing, make good responsible financial decisions for you. And in some cases, at some point, maybe withhold or withdraw life-sustaining care. So what you want to do is make sure that person is trustworthy and responsible. They can always hire help on the financial or medical decision-making to make sure they're making the right decisions. But the point that you want is you want them to be responsible and respectful of your wishes. But let's say someone didn't think ahead. Someone didn't get a lawyer, and someone didn't prepare and execute a proper financial or medical power of attorney. What happens next? Let's say you are now incapacitated. God forbid you didn't do one and you get into a car accident. You're now sitting in the ICU of a hospital, unable to communicate. Well, what happens there? Well, a couple things can happen. First of all, let's isolate the medical decision making. In Pennsylvania, we do have a fallback. It's a very poor fallback, but it is a fallback in emergency situations. It's called Act 169, and it is the healthcare representative law. So if there are people who are involved in your life and they are communicating with your medical providers and they are available, the medical providers, depending upon the relationship of that individual, could talk to them about your medical wishes and to authorize life-saving or not life-saving medical care. But it's going to depend. There is a hierarchy of individuals in the healthcare representative law, again, it's called Act 169, that are allowed to make decisions. Excuse me. The first person is typically the spouse. However, if it's a second or third or fourth marriage, and you have children from the first marriage, the spouse and those children are in fact on the same level. So if there's a conflict, they have equal decision-making authority, The second would be just children, regardless of whether they're from the first marriage. And then we have, surprisingly, siblings and then grandchildren. I would think grandchildren would come first based on other parts of PA law, but in fact, siblings come before grandchildren in decision making. So if there have medical issues that need to be addressed and you don't have that, then Act 169 may be a fallback that doesn't require a legal guardianship. However, on financial decision making, or if there's a dispute or conflict between the people who are trying to help you, you're going to need to go to court and get a legal guardian appointed. And in Pennsylvania, you need to typically hire a lawyer to do that. And then you go to a judge and you allege that the individual is incapacitated, meaning they lack the ability to make appropriate and safe decisions. You would need medical testimony. And a judge would then say, okay, we've declared you incapacitated and we've appointed this individual to make decisions. If you have a power of attorney in place and there are people who are in conflict, the judge can look at the power of attorney and use that as a guide as to who takes the highest priority. So that's another benefit to having a power of attorney in place, because under Pennsylvania law, if you have named someone as your legal agent under a power of attorney, they take priority in a guardianship proceeding as to the preference as who's going to be your guardian if there is conflicts or another need for guardianship. But ideally, in most cases, a well-drafted and well-executed power of attorney is all you need. In general, if there's a power of attorney in place, you should not need a legal guardian. But there are cases where there is disputes or the individual is acting in a way that the power of attorney or the agent isn't able to protect them from their own actions. For instance, this afternoon, I have 2 emergency guardianship hearings in Montgomery County. And one of the hearings is for a very lovely lady who is extremely intelligent, but is suffering from very mild cognitive impairment. And due to her cognitive impairment, she has been subjected to multiple financial scams where she's given away in excess of $100,000. She could execute a power of attorney, but because she will not cooperate and she is so vulnerable to being manipulated by the scammers, we have to get a guardian to protect her so she doesn't give away all of her money. And I have seen that happen multiple times in my career, where a person that you may meet at the Wawa buying a sandwich and look at this person and say, they're completely functional. They go to their doctor, they eat, they take their medication, but they're right at the beginning of cognitive impairment and their judgment is off and they are very easily manipulated. And it's a very scary situation, because if you met this person, you might not think she's in any way impaired, because in every other way in her life, she is completely functional. But that's where a situation where having a power of attorney would be useless, because literally this person, and this is, I've seen many times in the past, this person recognized that she was being scammed and then literally the next day went and started giving more money to a different scammer. So clearly there is some functional issue in her brain that isn't clicking and saying, my red flag should be coming up when these people are calling me and telling me I'm going to win the lottery, or I'm going to win Publishers Clearinghouse, or this religious organization, or if you get caught on the computer where somebody says, we need to get access to your computer to help you fix it because there's a virus, when in fact those people are charging you thousands of dollars and installing viruses so that they can follow you and get access to your personal information that might be kept on your computer. So the reason, number 4, why is a power of attorney one of the most important considerations in estate planning? You know, when I was a young attorney, federal estate tax was a concern. People worried about, 37 to 55% taxes from the federal government if they died. Today, most people don't have a worry about federal estate tax because the exclusion is so much higher. Today, the 2 things that people really, so your estate, just for reference today, so people understand what I'm saying, if you have an estate under $12.5 million for a single person or $25 million for a couple, federal estate tax will not apply. Pennsylvania has a modest inheritance tax, but it's not significant. So today, the 2 things that people really should be concerned of as they age are, 1, cognitive impairment, and potentially engaging in dangerous things that could harm you financially or personally, cognitive impairment and long-term care costs. Sorry, I'm having my senior moments. Thank you. 57. Long-term care costs are the new inheritance tax, because we'll talk about that. But long-term care costs are the things that people are most concerned about, and obviously your organization can help with that. Avoiding that or minimizing it or putting in a structure in place so that your care is the way you want it. But that's probably the 2 biggest things that are the risk factors in today's long-term care planning. If you could scroll down on or expand the whole page on your computer, there we go. So the 5th question is, and this is important again that people often misunderstand, is how does a will control the disposition of your IRA funds? Now, IRA funds are what we call typically a non-probate asset. So if you have a bank account and your name is on the bank account and you don't name any beneficiaries on the bank account, that will fall into your probate estate when you die, and it'll be controlled by your last will and testament. But if you have a beneficiary designation on that account, or you have an IRA or a co-owner or a life insurance policy or an annuity that has the opportunity to name a beneficiary, and you name that beneficiary, that beneficiary will control the disposition of that asset. So let me give you an example of where I've seen problems occur. So Mrs. Smith has $250,000 in a bank and a house worth $250,000 and maybe an IRA. And she opens up a new IRA at her new bank. And she goes in there with her son. And she has 3 children who she wants to treat equally. And her will says will be treated equally when she passes away. But she goes in there, and the bank employee, not knowing and just trying to be helpful, but ultimately not being helpful, says, hey, do you want us to name your son here as the beneficiary of your bank accounts in your IRA? And she's, yeah, sure, no problem. But the bank person didn't really know that she had 3 children and wanted to treat them equally. And then she passes away. And the only asset that is controlled by her will is her home, because she put a beneficiary designation on her IRA and on her bank account. And in 99% of those cases, the one child will simply do the right thing and take care of their siblings. But money changes people. And sometimes, and I've seen this happen, where accidentally a beneficiary designation does not include all of the people you wanted to treat equitably, and ultimately those people get cheated. My general recommendation for my clients is that, with the exception of tax qualified accounts like IRAs, 401ks, 403bs, or tax qualified annuities, all other assets don't need a beneficiary designation. Your will, or if you have a trust, typically have many more protective provisions that are important that do not come with a beneficiary designation. But because of the tax qualified nature of IRAs and retirement plans, there's a benefit to putting a direct beneficiary. Just make sure it covers all the same people you want to benefit. So I think it's important that people understand that a good estate planning attorney is going to ask a lot of questions and is going to go over these issues with you and make sure you understand the effects of certain decisions that you make. Because so many people speak to people in the financial services field who may not have the big picture or not be, frankly, qualified to be giving that type of advice. And then ultimately, there is conflict caused by the lack of advice or the lack of a full understanding of the client's needs and desires. Okay. Now, earlier I mentioned that the 2 biggest, concerns today are cognitive impairment and long-term care costs. So let's now quantify that. And again, normally when I'm doing this type of presentation, it's interactive. I'm speaking to people and they're answering this question. So it's not quite as much fun when I get to answer it myself, because oftentimes I get a variety of different answers that is very educational to the entire group. So first of all, let's talk about what's the average cost of care for a month in a nursing home in in southeastern Pennsylvania, which includes Philadelphia, Montgomery, Bucks, Chester, and Delaware County. If we're looking at a nursing home, and we have to define the differences, the average cost of care right now is probably between $13,000 and $17,000 per month for a nursing home.
I was going to say 10, so I was definitely under.
Yeah, there are a few nursing homes that are in the $350 to $375 range a day, but most nursing homes in southeastern PA are between $400 and $575 a day. So it's significant. Now, we want to step back 1 second and explain nursing home is the highest level of long-term care one could get. So we start with home-based care, which is for many people preferable, at least at the beginning of the care continuum. Now, home-based care, and you'll probably agree with me on this, today a private agency, a private non-medical home care agency is going to be between $30 and $35 an hour for an aide who is not a nurse, but is typically a certified nursing aide who can do personal care and other things, help assistance with activities of daily living like feeding, bathing, dressing, toileting, etc. But they're not legally allowed, for instance, to dispense medication. They can provide reminders, but they're not medical. They're not nurses. Once you start that process, once you are able, and again, there is adult daycare if someone wants to stay in their home and be supported by family and or home care. You could also work with adult daycare, which is kind of a day program that's usually around 8 to 5, 8 to 6, and provides assistance, a meal or two, snacks, showers, stuff like that. And then you come home to your loved ones and maybe additional care through your organization. And then we start the institutional levels of care. So from there, we go to basic independent living, which is basically an apartment with the I've fallen and I can't get up cord. It's not much more than that, although there may be communal meals and social engagement there available. The real first level of care is called personal care. Pennsylvania has what we call assisted living, but almost every facility that is called an assisted living is in fact licensed in Pennsylvania as personal care. Personal care could start as it's a very broad classification. There are some personal care homes that might be somebody taking 3 boarders into their row home in Philadelphia. And it could go anywhere from there to basic assistance, 3 meals a day, some socialization, to all the way to someone who needs a very high level of physical assistance, to someone who is very cognitively impaired and needs care almost consistent with a nursing home. So it goes from that very basic level of social engagement and 3 meals a day to getting all of your physical needs taken care of by someone else. So you're, from a cost perspective, again, you're probably starting at around $3,500 for the very basic level of personal care to almost $10,000 for a secured memory unit where you're almost at a nursing home level. And then again, nursing homes are probably about $13,000 to $17,000 a month. They are licensed as medical facilities. They are required to have registered nurses or higher in the building on every floor, 24/7, 365. Personal care regulations do not require nursing in the building, although the facilities that tend to keep a more frail resident base who have people who have much higher needs, some of them do in fact keep RNs in the building, but the requirements are very flexible there. So, you know, the ability, we have a lot of different care options, and there's a lot of different flexibility in the cost, but the fact is long-term care is expensive no matter how you look at it. What is Medicaid and how does it differ from Medicare? Medicare is health insurance for someone who is 65 years old or older, or someone who is disabled under federal law for at least 2 years. Medicare does not and never will pay for what we call long-term care. The only amount of care that Medicare will pay for in a nursing home is if you qualify under Medicare Part A, that's the hospital benefit, for rehabilitation services due to a medically related injury, and you spend 3 midnights in a hospital as an inpatient. And this is a very important issue because today many hospitals are not clear, and they will not admit you as an inpatient, and they will keep you on observation status, which is not part of Medicare Part A. It is part of Medicare Part B, which is outpatient care. And if you are not under inpatient care under Medicare Part A in the hospital, you will not qualify for short-term rehabilitation in a skilled nursing facility under Medicare. And this is very important. So when you are advocating for yourself or a loved one, you make sure that when your loved one is brought into that hospital and is told you are being put in a room, that they immediately confirm, and the hospital is required to tell you this, whether they are inpatient under Medicare Part A or being treated as outpatient under Medicare Part B. Because, again, unless you are inpatient for 3 midnights, you will not be eligible for inpatient nursing rehab. So it's very important people understand that. Okay, so Medicare will pay for some rehabilitation in a nursing home. The first 20 days is paid for fully by Medicare, assuming you've completed your deductible. Days 21 to 100 are paid with a copay. I believe it's around $200 a day. And typically, if you have a Medicare Part B supplement, that will pick up most or all of your copay. After 100 days, whether or not you are still in need of Medicare covered rehab services, Medicare will no longer pay. Okay, so that 100 days is finite and it is clear. You get that 100 days, but you have to also understand that if you go in and do not have 60 days between your last skilled nursing inpatient stay, you will not replenish that 100 days. So what happens is, let's say you go and you have an inpatient stay and you use 60 of your 100 days, and then you go back into the hospital before 60 days has expired. When you go back for rehab again, you have 40 days left to use. If you then have 60 days or more between that skilled rehab stay and your next one, your 100 days will replenish. Okay. Whereas Medicare is only going to pay for skilled rehab with the intention of dealing with a medically related issue, Medicaid, on the other hand, will in fact pay for long-term care in a nursing home and to some extent at home if you meet the clinical and financial requirements. What are they? The clinical requirements are that you are in a condition where you need significant physical assistance or have a significant enough level of cognitive impairment that you need a structured environment and supervision. So that's the clinical requirement for Medicaid. The financial requirements are very much on a case-to-case basis, but Medicaid is what we call a means-tested or poverty-based program. So the idea here is if you have millions of dollars, Medicaid isn't going to pay for your long-term care. You have to meet financial qualifications to do that. So it's very important that you think ahead. One thing that is very different and good about my practice today versus 10 years ago is 10 years ago, almost all of the asset protection, spousal planning I was doing was crisis work, meaning husband is calling me because wife is now in the hospital and is going to be discharged to a nursing home and he can't care for her. He recognizes that. And we've got to figure out how to pay for it and protect him because he's 74 years old, completely healthy, and could be around and independent for another 30 years. That's crisis. Today, I'm getting a lot of people now who are coming to me when there's an initial diagnosis of some dementia-like condition, whether it's Alzheimer's or Lewy body or Korsakoff's or whatever it is. I'm getting people on the front end now where we're planning out things so that it is not just the crisis when we start to plan and put things in place. There are certain things we have to do at the end, but the good thing is it's better to plan ahead and be prepared. And also, part of what we do isn't just the financial stuff, it's giving them options. It's saying, here is an organization that can help you if you want to stay at home. If you want to be in a community, here are other options that you might want to start looking into now. So, 7 and 8 really are about thinking ahead and getting your plans in place and kind of knowing what you want your elder years when you need help to look like. Now, let's be real. We're in America. Money matters. So if you have very limited resources, obviously you're going to have less choice. It's not a bad thing or a good thing. It's simply a fact of how our system functions. But the point is, getting your house and your affairs in order ahead of time is always better than reacting. It's better to be proactive than reactive. You're going to be reactive at some point. Getting older and having cognitive impairment is something that you can't 100% anticipate. Some people transition very slowly and are very functional for a very long time and don't need care. Some people it's like an on-off switch. One day they are completely functional, and then 6 months later, they are completely dependent on others. So I can't tell the future. If I could, I wouldn't be talking to you today. I'd be on my yacht in the Caribbean trading my stocks. But the reality is, it's better to think ahead than get left behind. That's the reality. So why is this significant for the average older adult? Well, I think you have that question answered already. The incidence of cognitive impairment is in excess of 50% of the population in the over 85 crowd. What I'm seeing, which is scarier, is when I was a young lawyer, most of the clients I was dealing with were in fact above 80 years old. Today, I am seeing dementia for some people in their 50s. I am seeing early onset and some very aggressive dementias for people. And I think it could be environmental. It could be the fact that we're a much more sedentary society than we used to be. We don't walk around. We don't do as much exercise. I think a lot of those things affect dementia. So maybe one thing you should get out of this is stay active, stay healthy, eat right. That's not, of course, legal advice, but you're getting, it's free, and that's what matters. So how do you qualify for Medicaid in a nursing home? Well, first, as I described before, you have to meet the clinical requirements, and those clinical requirements also apply to the Medicaid waiver program. Now, I mentioned to you earlier that you can get Medicaid to pay for services in the community. And ideally, the two programs are almost identical with the exception of one characteristic. If I need Medicaid in a nursing home, let's say that I have monthly income of $4,000 from pension and Social Security. And let's say that nursing home, all else being equal, I'm otherwise eligible for Medicaid and I have $4,000 a month. And that nursing home's negotiated rate with Medicaid is $9,000 a month, because each nursing home has a slightly different rate because of the illness level or the acuity of their residents. So some get a little more, some get a little less because their residents are sicker or healthier. So let's say I have $4,000 a month coming in, and the nursing home's negotiated rate with Medicaid is $9,000 a month. I will pay the nursing home my $4,000 a month. Medicaid will kick in the $5,000 difference. If I am looking to get Medicaid waiver services in the community, there is an income cap, and that's important. That income cap is $2,742 a month gross income, meaning before they take your Social Security Part B out of your check and before taxes are paid. So if you have gross income higher than that, $2,742 a month in 2023, and the number changes once a year, then you are technically ineligible to get Medicaid waiver services in the home, and you would have to go to a nursing home. Now, there is an informal, not in the books, not in the regulations, agreement that I have and some elder law attorneys have with the Department of Human Services, who administers Medicaid in Pennsylvania, that if the person is less than $500 over the Medicaid waiver limit, we have a workaround. So if someone is below $3,242 a month, we can still get them waiver services in the home. And also understand that if it's a spouse applying, only the applicant's income is counted. So if the two of you have $5,000 of income, but the applicant only has $1,000 of income, the applicant is still eligible for waiver service, because the income of the spouse, once you're on Medicaid, is excluded. So how do I qualify for Medicaid? Well, essentially, if you're an individual, there are limited assets that are considered off the table that they let you keep, like your home, like a car, burial reserve, a couple other items. Other than that, you're only allowed to have $8,000 of total resources to get coverage either in a nursing home or on waiver. If you're married, there's a lot of tools that I can use to protect assets for the healthy spouse. I can't go into that today. That's an independent discussion. And it's really very client specific, because certain assets have a preference as to the way they're protected and certain assets are exposed more. But the fact is, if you're married, there's a lot of tools that a good elder law attorney can use to protect the healthy spouse so that they are not made to be destitute paying for the long-term care of their loved one. Now, again, a question I love to ask, but can you get help to pay for the cost of assisted living or personal care? And unfortunately, in Pennsylvania, the answer is no. As I mentioned earlier, almost all of the communities that you have seen, like the Sunrises, the Brandywines, the Five Stars, they all are personal care licensed. Pennsylvania actually does have a separate licensing for assisted living. And when that licensing regulation actually came out in 2006, the intent was that for properly licensed assisted livings, they would be eligible to receive Medicaid funding. I have no idea why that has never been implemented. Obviously, it's been around now for more than 15 years, and we still don't have assisted living being compensated by Medicaid. I don't understand it. It would save the state money because there are many people in nursing homes who could survive in assisted livings. I don't get it, but and I've asked this question to people high up in the Commonwealth and never gotten a straight answer. Now that we have a new head of the Department of Human Services, and she happens to be one of the commissioners or ex-commissioners of Montgomery County, I might be sending her an email to ask her why we still don't pay for assisted living, because it would save the Commonwealth literally millions of dollars a year that can be put to better use, and a lot of people would be happier living there rather than in a nursing home.
Because New Jersey covers.
They do have limited assisted living in New Jersey coverage for Medicaid. It's not unlimited like a nursing home. They have limited beds. You can't just walk into any assisted living on Medicaid. And I'm not licensed in Jersey, so I can't give you comprehensive discussion on Jersey law, but I am aware that New Jersey has a limited number of assisted living beds for Medicaid. And I don't understand why we don't do it, because again, I think it would provide so many benefits for this Commonwealth, the taxpayers, and the older adults who need the care. But who is it for me to question politicians? So if you give a gift of money to a child, a friend, a charity, and you need nursing home care, how long will that gift potentially affect your Medicaid benefits? This is the term that many of you have heard of, but we want to make sure is the 5-year look back. So if you make a gift to your kid, a perfectly innocent gift, and then within 5 years need long-term care under Medicaid, Medicaid is likely to penalize you unless we can use one of the very few exceptions to that rule. And here's how they calculate the penalty. Every year, Pennsylvania comes up with an average daily cost of care of a nursing home throughout the Commonwealth. So this year, that number is $423 a day. So the average nursing home in the Commonwealth costs $423 a day. And what they say is they take the gift that you made, because when you apply for Medicaid, you're going to have to give them 5 years of financial information. So they're going to see every check you wrote, every withdrawal you made, every deposit that was made into your account. So they're going to see, oh, okay, you wrote a check for $30,000 to your granddaughter for her wedding, and then you applied for Medicaid 2 years later. Excuse me. So they're going to look at that gift and they're going to divide it by $423, and they're going to say, that's how many days you are not going to get Medicaid. So let's say you now have run out of funds, you have no money to pay for care, but you are now otherwise eligible to get Medicaid funding in that nursing home. But because of the gift you gave 3 years ago, you have a 150, 200 day ineligibility period. So that's a problem because you don't have the money. Medicaid isn't going to pay the nursing home. Somewhere, someone's going to have to give. That's going to have to come out in the wash. So that's why when you are thinking about making gifts in your senior years, you better be aware of how the law works so that you don't put yourself or your spouse in jeopardy. And I skipped number 12, and I didn't mean to. So the question on number 12 is, how much money can you give away in a year and not affect your payment by Medicaid for long-term care services? And again, it's the same context here that people misunderstand the difference between federal estate tax and Medicaid. Federal estate tax says you can give away $16,000 per person per year and not reduce your $12.5 million exemption. That has nothing to do with Medicaid. So if you give away $15,000 or $16,000 per year to your family and apply for Medicaid within 5 years of that gift, it will affect your eligibility and create a penalty. So people need to understand that under Medicaid law, with rare exception, gifting any money within 5 years of eligibility, small amounts like a Christmas gift of $100, as long as it doesn't end up being a lot of Christmas gifts to people in a given month, won't be a problem. But if you're giving away a couple of thousand, 5,000, 10,000, 20,000 larger gifts or assets that are worth it. So if somebody says, hey, Rob, can I give away my house can I sell my house to my son for $1? I would say, well, okay, if your house isn't worth $1, then that's a gift. So people need to understand that when you are looking at making transfers of assets First of all, another thing, by the way, if you are hiring care in the home, understand that if you're paying for those care provisions in cash, you are creating a nightmare for yourself down the road. Pay everything with check. Paper trail is really important if you need long-term care down the road. But the important thing is that people need to understand is giving away assets 5 years before needing care could cause significant qualification issues. If your spouse goes into a nursing home, how much will you be able to save to live on? Well, and that's part of the spousal planning that I mentioned earlier. So I'll give you just a quick understanding. First, there are assets that are protected. Again, the house, one vehicle, burial reserves. And then there are certain other assets that might be protected depending upon how they're set up. Then they look at the entire spousal estate. So this is husband and wife that are exposed. Then they cut them in half and they allow the healthy spouse, or what's called the community spouse, even if you're looking for waiver and they're still in the community spouse is the spouse that is not applying for Medicaid benefits. And if we look there, then the community spouse is allowed to keep one half of those exposed assets, but with a cap of $148,240 this year. So if you have $450,000 of exposed assets, the healthy spouse can only protect $148,240, and then we have to come up with a plan for the other money to be spent down in a way that is protective of the community spouse before we can get Medicaid for the applicant spouse. Now, I don't know what time it is. I'm thinking we have some time for questions.
We do. So I will moderate those. I just want to pull up here back to your contact. If somebody wanted to do a consult, they could call this number.
Yes, that is our main number, and we do consults. I can do them in person. We have my main office is the one you see up here. That is Plymouth Meeting. But we also have an office in Malvern and one in Radnor, right on Route 30. If people would prefer, and it's great, we could do a Zoom like we're doing now. I'm getting probably about a 50+% take rate on Zoom because it's very easy. You don't have to worry about parking or driving in traffic. And it's also great when you have your children, you want them to be involved in the consultation.
Sure.
If they're in different places, it makes it easier. But I'm happy to do in-person, telephone, Zoom, whatever's convenient for the client. They just call the 940-0650. We'll be happy to make an appointment. Someone will take a bunch of information. We will ask intrusive questions. That's what we do. And then when we do a consultation, there is a fee for that.
Right. Okay. So let's get to some of the questions, and we have about 15 minutes. So feel free to put them in the Q&A box and we will get to as many as we can. So
well, I'm going to answer the two that are showing up at 11:07 because I can't answer them. I'm not licensed in Delaware. Understand that Medicaid is in fact a state-specific law. It's joint state and federal law. Each state, unlike Medicare, which is all federal law and applies equally in all 50 states, Medicaid has unique differences in each state. So I cannot answer questions about another state's Medicaid law because it's likely to be different from Pennsylvania. Like we have certain protections of assets in Pennsylvania that they do not have in New Jersey, but New Jersey has assisted living on Medicaid. We don't have that in Pennsylvania.
Right.
So unfortunately, Jeffrey and Leslie, I do not have answers for you two. Bob, should a trust be cited for beneficiaries on bank accounts? I'm not 100% sure as to what the question really means, but I'm thinking what Bob is asking is, should a trust be named as a beneficiary? And a trust can be named as a beneficiary depending upon your individual circumstances. You can just name your estate, but in general for IRAs, that's where I recommend an individual beneficiary. But if you can name your estate as a beneficiary on an IRA, and if your will is set up properly, it can be kind of a flow through without requiring a full recognition of income of the entire amount in the IRA on the year of death. So you can name your estate. If you have a trust, either a lifetime revocable trust or a trust set up under your will, you can also name that as a beneficiary as well. Anonymous attendee. What is the difference between a power of attorney and a medical power of attorney? Well, a power of attorney is a broad description that includes a medical power of attorney or a financial power of attorney. But a medical power of attorney specifically addresses medical, healthcare, personal care decision making, whereas generally most lawyers separate those powers out, and a financial power of attorney is really only dealing with property decisions, accounts, retirement accounts, investment accounts, banks, assets, real estate. Those types of decisions are typically broken out into a separate legal document.
I'm going to pop up here so we're back together and I can kind of clear out some of these questions as we go.
Yeah, I think it's got to be more than just 4.
There's more coming in. I will say to the 2 that asked about Delaware, and you'll probably know more, Rob, there's the National Association of Elder Law Attorneys, that website. If you Google that, you can go and find somebody in your area to talk to.
Yes, very good point. We don't practice in Delaware, but if someone calls Heather, who is on here today, Heather, who works with me, we have a very nice, very capable elder law attorney that we will refer all of our Delaware cases to, because he's very experienced like me and seems like a real good practitioner.
Lovely. We have, Rob, somebody asking, what is better, a trust or a will?
It's really very client specific. So first of all, we have to understand that there are about 1 billion different types of trusts. What you're probably asking is a revocable trust. So a revocable trust is often used as a will substitute to avoid probate. If you're a Pennsylvania resident, probate is just not that big a deal. There are rare instances where I do recommend the use of a revocable trust. For instance, I have a client who came here from California and still maintains 2 condominiums in California. California's probate is a nightmare, very costly, very court intensive, very delayed. And so for her, we actually did create, even though her Pennsylvania estate is going to be administered very promptly and quickly because our probate is not bad. But since she has a piece of real estate in California, which will not be considered part of the Pennsylvania probate does not address foreign real estate. If you have a bank account in California, that's included in your Pennsylvania probate, no harm, no foul. But if you have real estate in California or New York or Florida, I will recommend the use of a revocable trust and putting that real estate into the revocable trust, because those states have a probate process that can be very trying and very expensive and painful. So in general, most Pennsylvania residents are fine with a will and powers of attorney. On occasion, though, we will do revocable trusts for clients with real estate in one of a number of other states that have a more complex probate process. New Jersey isn't one of them. So if you have a shore house, generally doing an ancillary probate for that shore house in New Jersey is pretty quick and easy.
Okay, thanks. This person's asking, I have been told that the 5 wishes document is valid in all 50 states, but also that POAs are state specific. Please comment.
Okay, so in fact, the 5 wishes document, to my knowledge, is valid in all 50 states. Powers of attorney are a creature of state law, so that while the 5 wishes document may, in fact, if you want to use that, may be perfectly fine for medical decisions, it will not be fine for financial decisions. So you would still need a state-specific power of attorney. I will also tell you that some people find the 5 wishes document to be a little overwhelming, and that part of the value of having an attorney is the questions, it's the things you discuss. It's not the documents. So yeah, if you want to do it all yourself, the 5 wishes document has a lot of options available, but the benefit of using an attorney is having someone to discuss with you things that can occur and why you might want to choose some option.
Thank you. This person's asking, if our daughter gets married and we directly pay a wedding vendor that she would use to get married, does that count as a gift, which Medicaid would look at?
Unequivocally. Unless you can somehow argue that you're getting remarried, that's going to be a gift.
You could have a double wedding.
Yes. If you can find a way to make this about you, Medicaid won't have a problem with it.
We have this question. If living at a true CCRC, how is Medicare Parts A and B applied?
Well, in general, when you move into a CCRC, almost every CCRC contract, well, every CCRC contract I have ever reviewed for a client says your medical care is not covered by what we provide service-wise. They will offer you physicians who come on site, or maybe they have physicians on staff, but your choice of insurance coverage is going to be your choice, and you will. Now, I will also tell you, though, that some CCRCs will recommend certain policy provisions, like in your B and C. For instance, some medical providers will not take certain companies and certain advantage plans, but practically, a CCRC is not in its essence a medical community. So your health coverage can be provided by your current physicians, and you should be buying whatever Medicare Part A, B, C, and D you want that suits you best.
There is some arrangement whereby one can hire a family member to help with tasks, including financial. Please discuss.
Well, there's two things I think are being asked here, but I'm not sure. So the one that I think may be being asked, I mean, certainly anybody who is your agent under a power of attorney is entitled to reasonable compensation for whatever they do for you. In other words, so if your daughter is doing what a bill paying service would do and charge you $75 an hour, theoretically, you can pay her $75 an hour. Although I will tell you that if you are working within the family unit, Medicaid will look sideways at that unless you have a regular agreement in writing as to what services are being provided and how they're being paid for. They won't object if it's done right and there's documentation as to what services were provided, how many hours were done, and the payment, but it's got to be done if you're using family. It's got to be done officially and appropriately in writing, and you got to have a paper trail. If you're talking about Medicaid, so within the Medicaid waiver program, there are some people who actually, instead of using a outside home care agency, will pay a loved one who's already doing the work to be the provider of home care. So typically, to make it easy, there are ways to get around the rule, but in general, it's much easier to simply have the loved one be hired by a Medicaid-approved home care agency, and then they will pay the agency, or Medicaid will pay the agency, and then they will pay the family member. However, there is a restriction there. If the family member who is actually providing the care is a legal guardian, an agent under power of attorney, or a spouse, the law prohibits them from getting compensated. So if you have a child who has moved in to do this for you, and they are not your power of attorney or your agent, then they can get hired and get whatever the going rate is to care for you. But if they are, in fact, your agent under power of attorney, then they are not going to get compensated.
Is there an advantage to not being married to protect assets? My partner and I have been together over 30 years and never got married, in part to protect our separate assets.
Yes, because until you are legally married, Medicaid looks at the contract. So unless you are married legally, then your spouse, your partner's assets are not accessible for your care, and vice versa.
Oh boy, don't tell my boyfriend that one. What's the best way to deal with passwords? I'm thinking of writing them by hand so they won't be in the cloud, and putting them in a safe deposit box and share that box with one person.
I think that that's not a bad idea, except cancel the safe deposit box. Just put it in your house and tell that one person where it is. Safe deposit boxes are not accessible in the evenings and on weekends. I think that's a fine way of dealing with it. You know, there are password software programs that you can use, but I think anything offline is certainly safer than online, because clearly, you know, there are organizations, horrible people who can get access to your system if you hit a link one time accidentally. So that, you know, putting stuff on paper and just keeping it in a safe place is not a bad idea.
Thank you. And I am keeping the eyes on the time. We have about 5 minutes, and Rob has those 2 emergency hearings. So we're just going to see what we can get through. There's about 6 more questions. We'll see what we can do.
Okay.
How are IRAs treated in the calculation of protected assets for Medicaid purposes?
Well, typically, and again, it's really a client-specific thing, but typically your IRAs are exposed, your personal IRAs are exposed for Medicaid, so you can't protect them.
How to properly set up a pour-over will so that all assets are turned into a trust to avoid probate?
Well, first of all, if you have assets that are not in the trust, you're not avoiding probate. The idea of a will is that if you have to use the will to administer any assets, they're going through probate. But again, in Pennsylvania, probate is not a big deal. And there's no reason for a trust. If you live in another state, then the idea is if you really worry about the probate in that state, you should fully fund the trust with all of your assets prior to your death.
Question from Maggie about the questions that we shared on the screen. Yes, I will get those out. If you signed up for this, you will receive an email with those questions. The next question, did I understand correctly that you believe we don't need to name a beneficiary for bank accounts?
Correct. Yes, because the bank account will then fall into your probate estate, and the protections that are provided in your will apply to that account.
Okay. And what is a lifetime trust?
Okay. There is a living trust, which is what I think you're referring to, which is simply what is a revocable trust that you create and fund while you're alive. Because it's revocable, all the assets are considered yours. Your creditors can still get at it, but it does, assets that are in that trust technically avoid probate. But again, in PA, probate is not an issue. A revocable lifetime trust or a living trust is again beneficial if you have real estate in one of the bad states for probate, so you can avoid probate for that property.
Thank you. And someone else asked again about the National Association of Elder Law Attorneys. That is NAELA.org. Or as Rob mentioned, reach out to his office. He's got somebody in Delaware he likes. I'm sure you have a recommendation in New Jersey that you would use, hopefully. And I see one more, and this will be our last one, and then we'll let you go. Yes, this person's asking, can we review this program? It is recorded. You will get a recording so you can review it again. So thank you, Rob. We really appreciate all you've done for us this year. And this was very helpful, I'm sure, for a lot of us. So thank you for making the time.
It was my pleasure, and thank you for having me.
Good luck at your hearings.
Thank you. Have a great day.
Bye.